Some housekeeping items. This webinar is being recorded. A recording will be available on our website at www.sanpabloedc.org. Any resources mentioned during the presentation will also be available on our website. All attendees are muted. If you have any issues with audio, you may need to click on the webinar screen to enable audio. We will welcome your questions. Please type them in the Q&A box. We will answer them at the end of the webinar if the time permits. A little bit about San Pablo EDC. The mission of San Pablo Economic Development Corporation is to act as the catalyst for equitable economic opportunity. Some programs and services we offer is to support advancement, and we focus on employment training and support, home ownership, business resources, and access to capital. With us today, we thank our partner, Mariana Acevedo Nuevo, a clinical supervising attorney at Berkeley Law. I will now stop sharing, and Mariana will share her slides.
Hello, it's very nice to be here, and I hope that you'll find this presentation interesting. I am going to very quickly go over a series of resources and things that new businesses have to go through in order to thrive. First, I also want to say that this does not substitute for legal advice. This is an introduction to legal issues that commonly affect small businesses, and it's not a substitute for consulting directly with a lawyer, which is always recommended. So first, I want to say that this is exactly how starting a new business feels like sometimes. So that for the uninitiated is Modern Family, which is a show. And we like to use that clip because sometimes it feels like there are so many requirements that you need to go over before you can even start a business, no matter how simple that business might look like at the beginning. So we've come up with an acronym that is become a survivor, which is business modeling, entity formation, capitalization, operational relationships, how to manage risk, and lastly, a couple of extra permits and licenses. Hopefully, I will go over these relatively quickly, and we'll be able to have a few questions at the end. So first, the business modeling side. Honestly, I like to skip over this part because I know that you have access to other resources that go, deeper into the business side of starting a business. And I like to go over the legal side of starting a business. But we often like to say to our new clients that having your business model with you will help your attorney and will help people that are trying to help you understand what are your key partners, what are your key activities, how and what you like based on the things that you want to do. There will be certain risks, and if we know what those risks are, we might be able to help you mitigate them before they get to be a problem. So this is why we normally require our clients to have a business model in place before we start helping them out. All of these relationships, for example, are normally modeled through a business contract. Like you can have a master service agreement with your client, you can have an operating agreement with your business partner, and a lot of those relationships are modeled through a legal document, an agreement, or a contract, however you want to call it. That being said, I'll go over to the thing that I get most often asked about. I do like 3 webinars a month, and in all of those webinars, people want to know like, hey, what entity should I choose? And I like to tell people that choosing an entity is like choosing a vehicle to start in that metaphorical road of starting a new business. So here are the options. There's a sole proprietorship, a partnership, a corporation, or an LLC. I'm sure that you've heard the words LLC a million times, and also sole proprietorship. So I want to say that these two first are not an entity. They do not create a separation between you and the business. Neither of these options are limited liability entities. So if you do not make a choice, like a conscious choice, the government will assume that either you're a sole proprietor, or if you're doing a business with someone else, you're a partnership. So let's say you want to start selling hot dogs. If you just take your hot dog cart outside, the presumption, if you're doing it alone, will be that you are a sole proprietorship from the moment you take your little hot dog cart outside. And if there's more than one of you, if it's you and your friend taking the hot dog cart outside, then it will be considered a partnership. And again, this is not a limited liability entity. So a lot of the time, people are like, okay, so what should I consider when starting an entity? And there's 4 questions that we normally like to think on when advising you what entity to choose. The first is, who should make decisions for your business? A lot of the time, the answers to these questions are going to be completely, not a lot of the time, all of the time, the answers to the questions are going to be exclusively determined by the type of business that you're going to do. Let's say that you have a little money on the side and you and a friend want to start a restaurant, just like as a side gig, and you want to hire a manager to run the business, and you only want to be the owner, then that person, that manager, is going to be the one making decisions for your business, and you're just going to be like a silent investor. How should the business's income be taxed? That's another very important question. Do you want to have double taxation, which would be a corporation, or do you want to have pass-through taxation, which would be an LLC? Liability. Do I need a legal liability backstop to protect myself? So there are businesses that carry inherent risks. For example, selling food. Selling food is often a risky business because if you have a hole in the wall, let's say you have a mat and someone comes over and trips, and now you're on the hook for whatever happened to them, that has a lot more risk than maybe selling some clothes on Etsy. Those two businesses have completely different levels of risk, and therefore my answer to what entity should I choose would differ based on that. And the fourth question is, do I need a vessel for capital providers to pay into? If you are looking to be the next Uber, the next Airbnb, you're probably want to choose a very specific entity, because the investors that you're looking to get money from are going to want to see that entity as well. What is not as important? This not as important, again, depends on your situation. So a not very important question is, what's the easiest to form? Because it's actually really easy to form any entity in California, really easy. We have presentations available and we can talk through them in a one-on-one consultation, and you could potentially have your corporation within like 15 minutes of starting the process. Another question that you maybe should not be asking yourself is, what are the lowest filing fees? LLCs and corporations cost $800 a year. No matter how much money you're making, you're going to have to pay at least $800. And if you're making over $250,000, you're going to have to pay even more than that, just as a franchise tax, on top of like all of the other taxes that you're going to be that you're going to need to pay. So sometimes people are like, oh, don't worry about it, it's only $800. But based on your business, if you are selling like as a side hustle on Etsy and you're not making a lot of money from it, maybe for you $800 is just going to be a very big deterrent. So that's why I don't have a one answer fits all solution for each particular business. And as I said, there's not a lot of paperwork for any of these. So, well, I forgot that this slide was here, so I already told you all of these. I am going to just click on it and go to the next slide. So again, these are the three most common entities: the corporation, the LLC, and the partnership. So the corporation, you have to form a board, and the board makes decisions. But in California, your board can be a single person if the corporation is made of a single person. If you have two people in the corporation, then your board needs to be two people and three people and so on. No, just three people. If you have a three-person board, then that's enough, even if your corporation has five people. Also, again, as I said, both of these, the corporation and the LLC, have an $800 tax associated with them. If you're looking to form a nonprofit, then the first step to form a nonprofit is to form a normal corporation, and then you apply for the tax exemption. Both a corporation and an LLC are limited liability, and both of them accept personal funds, debt, and members' equity as what do we mean about shareholder or members' equity? In a corporation and in an LLC, it is an often recourse for people to sell either membership units for an LLC or shares for a corporation in exchange for money as investments. So let's say you want to bring in one of your cousins who has a ton of money on the side and is looking for an easy investment. Then what you would do is give them a little bit of equity, maybe 30%, 40%, whatever, in exchange of money that would not be considered debt, but an investment. And in exchange of that money, they would get equity, shareholders' equity or members' equity. In a sole proprietorship or a partnership, the main difference is you have personal liability and you have to pay self-employment tax, which is also something that you have to do for an LLC. The only time that you don't have to pay self-employment tax is in the corporation. So often I get the question of where to form. A lot of people get this information wrong because there's plenty of information on TikTok and whatnot that says, oh, corporations in Florida or in Arizona or in wherever don't have to pay any tax, and you should definitely form in Arizona because there are no laws or whatever, and people believe or somehow get like confused about the fact that if you're operating out of California, even if you form your company in anywhere else that is not California, you will have to comply with California law and you will have to pay the $800 minimum franchise tax. Because if you form in Arizona and then you operate from California, you're going to have to register as a foreign corporation. And that foreign corporation is going to pay the same $800 as if it were a corporation formed here. So therefore, if you are considering forming somewhere else to avoid paying those $800 and in general to avoid California rules, it is not worth it because California will make you register as a foreign corporation or LLC here. Now, if you're planning to become the next Airbnb or the next Uber, it is always really important to form in Delaware. Why? Because in general, venture capitalists, which is like the people that give money to these corporations, want to see the same form of entity over and over again. They really like repetition and they really like conventions. And they really like the fact that in Delaware, there is a very well-developed law and specialized business courts. So it is the choice for people who are trying to go the publicly traded company route. So if you're aiming to be a huge corporation, you probably need to form out of Delaware. Now, where I want to talk a little bit about capitalization. So we all need I often feel like this slide, we tend to overdo it because you only know why you need money. I don't think that I need to explain that. There's a million things that you can get money from. But what I do want to say is you will be getting this money from founders, family and friends, banks, equity investors, grants, government, etc. So what we want to highlight is that you need to have a balance between the sources that you're getting capital from. So if you get, there's three main sources. One is personal funds, the other is debts, and the third one is selling ownership, what I mentioned before. The advantage of getting the funds through your own money is that you don't need to pay it back if you fail. It's just your money, you lost it. But you cannot bankrupt your own family. If you get the money through loans, there is the plus side is that you will not be needing to give control of your company, but you do have to pay it back. In equity and selling ownership shares, you do not need to pay it back, but you are gonna be giving up control. So I want to highlight here that a problem that I've seen quite often, or often enough, which is you go out and ask your body to give you a couple of $1,000 for your business. And because there's no document memorializing the transaction, one of you thinks of it as a loan and the other one thinks of it as an investment. And that difference is really important and can cause so many problems down the line. Why is it really important? If you don't write it down somewhere, what you are actually expecting from this money, the problem will always be that there's a misunderstanding about whether you need to pay back the money or not. If you don't write it down up front, then you risk that the other person is gonna wait it out to see whether your business thrives or your business fails. If your business thrives, they're gonna say, oh, I gave that to you as an investment and I partially own that business, and therefore I should be included in all the money that you're now making. But if your business doesn't thrive and it goes the other way and knock on wood, it starts going under, they're gonna wanna see that as a debt. So you're gonna have to pay it back even though your business is doing really badly. Which is why we always advise for there to be either an IOU or a document just saying this is the rate for this is a rate, this is the term of the loan, these are all the conditions, this is what I'm expecting from you. You have to pay it monthly in installments, or you have to pay it all the way at the end, or whatever. So that's one thing to look into. This is often how a typical capitalization round goes for most companies. An LLC, a partnership, or a small corporation will often get to this part of it, which is just putting up your own money or taking debt. And if you want to go the public corporation route, if you want to be traded in Wall Street, you normally try to get venture capital, then a second round of venture capital, and then IPO. Most people, though, want to stay here, which is just raise a little bit of money, either through debt or through equity, and then just trying to grow the business that way. So one question that we get often is, where can you find capital? And obviously the loans from banks or private lenders, Kickstarters, and selling ownership and shares to investors. In terms of loans from banks or private lenders, as I was mentioning, we need you to use a promissory note. The promissory note needs to include the amount borrowed, the interest, the repayment schedule. If there is a collateral just means I am giving you my house or my car in exchange, like as a kind of promise that if I don't pay you, you can collect your money through this collateral. And what would be the default process, which just basically means if I don't pay, how are you going to collect the money back from me? Another very strong, another thing that has to be included is who is responsible for the repayment, the individual or the business. What do we mean by that? If you come to us and have a meeting with us, we're going to very likely advise you to form an entity, either an LLC or a corporation. And one thing that we're going to stress is that the moment you form your LLC or your corporation, you need to start signing everything going forward under your corporation or your LLC's name. What does that mean? Instead of signing Mariana Acevedo Nuevo, period, I would say Mariana Acevedo Nuevo, CEO of company X, or on behalf of company X. Why? Because we want everything to be laid at the feet of the entity. We want all the responsibilities to be the responsibility of the entity. So if I sign a promissory note on behalf of myself, then everything I own is on the line. Is like everything I own is on the pool of things where banks or creditors can collect from. If I sign on behalf of my business, then only the business is responsible for the repayment, not me, which is really, really important. And it's a huge difference. And a lot of people sometimes tell me, almost always tell me, well, you know what, actually, Mariana, I don't have anything. Why wouldn't I sign on behalf of myself? Or why do I need an LLC? I don't have a car, I don't have a house, or my car is really old, so it's fine. But what I want you to know is that is not a very good technique, just because remember that if you owe money, they can sue you and that debt can follow you around. And how do they follow you around? They do something that is called garnering wages, which is they kind of send a notification to all your future employers and say, hey, the moment you pay this person, you have to make a little bit, put a little bit on the side so that person can pay me. So remember, it is really good advice and an idea to always sign on behalf of the business, particularly things that put you on the hook, like promissory notes. And also, if you can, have a lawyer review any loan agreement before you sign. Another way to do this, to raise funds, is you can do it the Kickstarter route, which is just to pre-sell the product and on like a platform like Kickstarter, where you kind of say like, hey, you know what, I'm actually creating these new sneakers, and these are the sneakers, this is how they look like. If you buy from me now, you will get it at a discount rate, or you will get 5 pairs instead of 2, or whatever. This helps businesses often raise money to start their new dream. But there is another thing that people sometimes do that is potentially a little bit riskier. If your business is an LLC or a corporation, you might be tempted to sell ownership of your business, either through membership units if you're an LLC, or shares if you're a corporation, where the investor gets a portion of the profits in exchange of a right to exercise some control over management. That right to exercise some control over management usually looks like they have a right to inspect your books. They have a right to have an accountant review all of the books once a year, or anyway, just kind of inspect whatever it is your business is doing. But just so you know, this is a very regulated action. You cannot just sell ownership or shares to investors. There are a number of rules that are very complicated and I won't explain here, but normally you're looking to get something that is accredited investors, and accredited investors are just rich people. The SEC doesn't want you trying to get money from people that don't have money. So it is a very, very regulated activity to sell ownership or shares to investors, particularly if it's not like your friends and family. So one way to sell ownership shares would be through crowdfunding. And this comes with its own rules. And the Federal Jobs Act allows only limited sales of securities to non-accredited investors, which again, when you read accredited investors, read rich people. The amount a company can raise each year from equity is very low, and it limits the total percentage of income and the total amount of money that you can invest per year. You can arrange this through some portals and websites that have come up in like the last couple of years. And these portals and websites kind of cover all the rules. So if you're gonna do it, it would be a good way to do it through a secure, like through a website that already has this control setup. Now, if you go it, instead of going it through a crowdfunding website, you do it on your own. Let's say you go to the church and you're trying to sell shares to your fellow churchgoers. This is a very complicated, again, it is highly regulated by the federal SEC and by the state of California. You have to use one of the small business exceptions, which have a lot of paperwork, and you have to do the paperwork before you sell the shares. You cannot just go to the church and be like, hey, as of now, I'm just going to start selling, a percentage of my business, and then you go and tell the state. No, you have to tell the state first, and then you can sell the shares. Again, you usually can only do this to insiders, which means friends and family, and accredited investors. Again, here highlighted capital letter. Accredited investors usually means rich. There's an income limit. I think they have to be worth over $1 million. And you cannot advertise the sale. The other day, a local business sent out an email that I was like, I am pretty sure this is illegal, because they were trying to raise money. I understand why they were trying to do it, because they really needed it, but they were trying to sell shares, and it was advertising, and it was kind of really thinly veiled sale of shares, and I think they got in trouble. And this is like, when I mean that you have to file for a small business exception, the most common exception is a Rule 504, which is you can only raise $1 million in any 12-month period, meaning you cannot be, doing a sale to your church, raising 1 million, and then another sale and another sale. You can only raise 1 million in any 12-month period. You cannot advertise it. You can sell to insiders and accredited investors. So probably, like, if you are doing a church, related sales of shares, you're gonna want to be in a church where a lot of rich people go. No financial disclosures are necessary, but are still recommended. Can only sell restricted ownership shares, which means they cannot be resold outside the company without incurring disclosure and SEC registration. What does that mean? If you sell a share of your business, that share cannot be resold by that person to someone else, because then it could be considered kind of like a scam, like, oh, you sold me a couple of shares and then I took those shares and I embezzled someone else with those shares. So it's a restricted stock, which means you can only sell it once and that person has to keep it. And if they resell it, they have to register with the SEC. And within 15 days of issuance to an investor, you have to file all of these forms, and you have to file with the state. You should always talk to an attorney before selling equity shares. Again, this is because it is really, really regulated. And when they mean accredited investors, you have, again, it's a very small pool of people that you can draw from. Now, we want to talk a bit about operational relationships. The relationships that are most commonly known are capital providers, workers, suppliers, and consumers. What does that mean? The four kind of relationships that you will have as a business owner most frequently, first are with capital providers that we've covered a little bit, the investors, the potential contracts with people that loan you money, etc. The other is with your workers. The other is with your suppliers, which means the people that sell you things. And the other is with your consumers. As I mentioned at the beginning, you're probably want to set up all of those relationships via a contract, and you're going to want to know all of the legal requirements that you need to get set up before you start. You need to know what is government required, what is the minimum necessary thing that you have to write down in there, and what are the optional things that you could consider including. I'll start with the worker side of things because this is the thing that we see most people get in trouble. There are three buckets. The first is employees. The second is independent contractors, and there is interns. So anyone who works for you or who participates in your company is going to fall within one of these three buckets: employees, independent contractors, and volunteers or interns. If you are a for-profit business, you can never have a volunteer. I know that people are like, why can't I have a volunteer? This person just wants to work for me for free. It is not okay to have a for-profit business and not pay someone minimum wage. If you have a for-profit business, you have to pay someone minimum wage. The only potential exception is through an internship, but that internship has to be set up really carefully, and it has to come with educational benefits for the person who's at the other side of the internship. So let's say you hire an intern, and that intern is working for your company. If that intern is not making minimum wage, he better be getting an educational benefit or have some sort of credit from their school or whatever, because otherwise it could be a very difficult problem for you. And if you're gonna set up an internship program, just know that one of the requirements is that your interns cannot be substituting other employees. Like, they have to be doing something that other employees cannot do, and the internship has to benefit the interns more than it benefits your company. So in short, I would say if you're a for-profit business, try to not set up an internship program, and if you do, come talk to us, because there are a couple of requirements you have to do first. Now, most people will fall within the employee bucket. The presumption is that all people who work in your company are employees. In order to consider your employee an independent contractor, they have to pass the new test, which is the ABC test that I'll cover in a second. But if they don't pass that test, they have to be an employee of your company. California is an at-will state, but this is a highly regulated field, and we have a presentation that we can share with you, which is the 17 plus federal and state requirements needed to have an employee. It's like workers' compensation, everything you need to do, how to keep track of their hours, etc. We highly recommend you use a payroll service to manage all of the requirements. Now, a lot of you, or I don't know, whoever is watching may be wondering, like, okay, but how can I set up an independent contractor contract? First, it has to be arranged in a written contract. You cannot have an independent contractor if you do not have a contract with them. You cannot set up an independent contractor just by like talking to them and be like, hey, do you want to be my independent contractor? No, you have to have a contract with them. And the test that I mentioned before that the independent contractors have to clear is that it's called the ABC test, and it has 3 prongs. I like to think about it as like the head, the heart, and the feet. So what I mean by head is you cannot control the independent contractor a lot. You have to pay them by project, not a salary, and you cannot set their hours. You cannot use them for key positions. This person has to have freedom. For example, if you run a restaurant and you're hiring like a plumber to come once a month, you cannot be kind of saying, oh, you have to be here from 9 a.m. to 3 p.m. every day. You have to wear like this uniform that I'm providing, or I'm gonna control your agenda. You're gonna come like do this client now, this other client then. And it's like it has to be free. So you cannot control their head. The hard part of it is that this person cannot be used to provide the core service of the business. That's the hard part of it. So let's say that you are running a restaurant, and that restaurant, you're trying to hire the cook as an independent contractor. That's gonna be a very tough sell for the judge, because the cook is basically doing the heart of it, right? The focus of the business that you're doing is being run by the cook, and it's gonna be very hard to sell that they are not at the heart of the business. And the independent contractor needs to have their own business and be able to work for others. So what do we mean? That's the fit side of it, which is it normally pays off if the independent contractor that you're trying to get to work for you has their own business and can do this for other people. So say you have like a printing business and you hire someone in particular to print out, all of your cups because you don't have the right equipment for that. That person should be able to sell cups to others. They have to be able to not only offer their services to you, otherwise it's gonna be kind of suspect that they should be your employee. There are big penalties for misclassifying people. This is why I am staying so long in this side, because it's really important. If you misclassify someone, it could come with a lot of financial burden for you. Now, there are a number of reasonable steps that you can take to manage the risks. First, we recommend that you form a limited liability business entity, either a corporation or an LLC. The reason for that is just because you'll be creating a separation between you and the business. And in that separation, you're going to be able to protect some of your assets. Again, that limited liability is not like complete. Let's say you are driving a car and like for your business and you drive someone over, but you were drunk, then that's probably the limited liability is not going to protect you then, but it's going to protect you in many other instances. Then you're going to want to purchase insurance, and we recommend that you use a broker. I don't know why, but there are some people who are scammers out there and sell really terrible insurance, particularly for transportation businesses. Another thing that we often advise is you're going to want to control your agents. What do we mean by agents? Your employees and your volunteers. It is really important that you screen, hire, train, and supervise carefully. What do we mean by this? When I say that the limited liability is not it's not absolute, that there are things that could pierce your limited liability, one of those things that could pierce your limited liability shield is failure to screen, hire, and train, and supervise carefully your agents. What do we mean? If you are running a daycare business and you're supposed to run a background check on your employees because these people will be dealing with children, and you're supposed to train them about, for example, mandatory reporting, and you fail to do it, and then there's a problem, you could potentially be held liable because you failed to act responsibly and control your employees responsibly. Another thing that we recommend is that you indemnify your agents, e.g., your employees, your boards, your volunteers. What do we mean by that? Sign indemnification agreements, particularly with your board and your top employees, just to say you are indemnified from like potential liability from let's say shareholders suing you because of reasons of how you run the business or whatever. Then you're going to want to use contracts and limit the liability through those contracts. What do we mean by that? If you, for example, hire an employee and you make it really, really clear what their obligations are, and the fact that the information that you'll be sharing with them is confidential, and then this employee goes on and shares the information, your client's information with everyone, the contract is gonna state that those employees are in breach of the contract that you had signed with them, that you had explained to them, that you had trained them to comply with, and then that way you're gonna limit your own liability. If, on the other hand, you don't make your employees, you're dealing with children and you don't make your employees sign NDA or train them, or just in general let them know that your client's information is like not to be shared, and you're not gonna take pictures of people coming into the spa or whatever, then you're gonna be risking yourself, and you're not gonna be taking the correct steps to manage your liability. We also recommend that you choose your activities carefully. Sometimes I hear really interesting business plans about, children and having children where people are drinking or where people are working, and at the same time those children being unsupervised. And although it sometimes is a very promising business idea, the business idea might need some modifications in order to work properly. If you can avoid risky activities, although I know that this is sometimes not possible. All of the above efforts help the leadership meet what it's called fiduciary duties. Every person who is an officer or a board member of a corporation or a company has something that is called fiduciary duties, which is the duty of care and the duty of loyalty. It mostly means do right by the company. You are being entrusted to do right by the company. And if you do all of these steps, along with a couple of others, you're going to be doing right by the company. Another way to manage risks is securing the IP is intellectual property for the company. What is intellectual property? Intellectual property is all of the property that is not tangible. For example, if you have a restaurant, the logo, the catchphrase, any of the art or designs that belong to the company, the recipes maybe, and all of that has to be secured. And the way you do it is by having contracts. These are the intellectual property legal protections available to you. And depending on the information that you're trying to protect, or the product or process that you're trying to protect, is the legal protection that you're going to use to protect it. If, for example, we're talking about the recipe, for example, the secret recipe of Coca-Cola, you're going to want to use something that is called a trade secret to protect a company's secret information regarding products or services. It requires to take the reasonable steps to protect the secrecy, and you don't need to file with the state or with any other agency to protect it. What do we mean by trade secrets? The most famous one, again, is the recipe for Coca-Cola. And in order to keep that safe, they keep it in a safe. They make everyone sign non-disclosure agreements. They tell everyone, like, this is really, really secret. Don't share it with anyone. They don't just leave it lying around. What could potentially be another trade secret? Clients lists. Let's say you have a client list that you have devoted yourself to create. For example, if you're selling tostadas or if you're selling salsas or whatever, and you have created like a list of 500 vendors that sell your salsas throughout California, that list costs a lot of money because it took you a long time to complete it. It's something that is really important to you. And now you're giving it to your vendors for your vendors to reach out to these particular points of sale. And you want those vendors to not be able to use that list for themselves. Well, that is where you would make someone sign an NDA, and you would, tell them, like, this is a trade secret, you can never use it, it's really important, etc. If you have, let's say, an invention or a product or a process that has a unique design or utility, you can file a patent for that. And for that, you do need to file with the USPTO, which is the US Patent and Trademark Office. Same, and another thing that you can use is a copyright, which is to protect the content of creative works, meaning books or music, from people using it themselves. I don't know if you've used YouTube, but if you try to use someone else's video in YouTube, they will very quickly come at you and tell you, like, hey, you're violating someone else's copyright, etc. So in order to enforce your copyrights in a lawsuit, you must file with the US Copyright Office to obtain federal protection. And now Uh, the most common one that most people ask me about is trademarks. If you want to protect your logo or your name or your logo and your name, there is a filing that you have to do with the US Patent and Trademark Office, which is just protecting the marketing aspects of products. And I feel like if you are wondering, what do you mean by that? If I tell you now to close your eyes and tell me, like, what is the logo for Coca-Cola, you'll be very able to tell me exactly how the white font, like, reads, just exactly like the very, very famous lettering, etc. So if you want to protect your logo, you will have to file a trademark with the US Patent and Trademark Office. Now I want to talk a little bit about the extra permits and licenses because we're almost out of time. Um, And what we want to highlight is that you have to normally have a business license and a DBA or fictitious business name. That is pretty much across the board. Particularly if you don't have an entity, you need to have a fictitious business name statement and you need to have a business license. If you're doing business in multiple cities, you need those like multiple business licenses. And if also normally what you need is a seller's permit. In this link, which is calgold.ca.gov, there are a number of different types of businesses that you can locate, and they will show you what do you need to start that business. And that's it. I don't know if there might be any questions. If there are no questions, you can reach out to us at that email, and you can set up an you can set up an appointment with us,
I
and
have
that's
a
it.
question, Mariana.
Uh-huh.
So I actually have a business owner. So he set up think of like a online like clothing service, and
Mhm.
he did a LLC, and he called me the other day and said that he wasn't aware that he had to pay like the $800 a year. So he like accumulated over like a couple years. So like now he's like struggling to pay that, and he just wanted to know like um if it was worth like keeping his LLC. But hearing your presentation, it sounds that like there's not a lot of liability that he should protect himself from, right? If he owns just like a clothing
He
company.
should set up a he should set up a payment plan. They will never they will follow him around.
Okay.
He should call the franchise and tax board and try to set up a payment plan for them.
Okay. So I
I
might grab.
actually,
Go ahead.
yeah, this is a very common problem, but they do find them. And the best thing he can do is try to get ahead of it, find them, and try to set up like a payment plan. Because they will find him and they will collect. I have a couple of clients in that like particular problem. So I'm trying to actually talk to someone at the FTB and be like, why are you so mean? Because they truly will chase people.
Okay. So I will relay that information with him, and maybe have him connect with you guys on that end. Um so yeah, I'm gonna share um so Mariana Acevedo Nuevo, thank you again. Clinical supervising attorney at Berkeley Law. Her email is right there. It's Mariana1701 at berkeley.edu. Um, we went through Q&A. My name is Marco Sandoval. I am the business program coordinator for the San Pablo Economic Corporation. My email is marcos@sanpabloedc.org. My office phone number is 510-215-3204. If you guys have any questions regarding how to start a business or grants, please give me a call. Um, if you also have a question in regards to the different laws regarding to different entities when starting a business, you could refer to Mariana's email, or you could refer to me and I'll send you that information. With that, that will conclude our session today. Thank you so much, Mariana, for being with us. It was a pleasure.
Yeah. Thank you. Bye.